everyone, and welcome to another episode of Designing Justice. I'm Priyambada Shivaji.
And I'm Shreya Tripathi.
We are part of the Justice, Access, and Lowering Delays in India initiative at the Vidhi Center for Legal Policy. Through this series, we have been speaking to various stakeholders in the justice system to identify areas ripe for intervention and potential solutions for building universally accessible, inclusive, future ready, and better courts for all. Today, we're speaking with Advocate Meghna.
Meghna has worked as a law clerk cum research assistant at the Supreme Court and the Karnataka High Court. She's currently working as an associate with Dhwani Legal Trust. The Dhwani Legal Trust is a not-for-profit organization which aspires to provide legal aid and assistance to all, instilling faith in the due process of law among the general public through affordable, reliable, and approachable legal aid and support. Dhwani seeks to ensure that every individual has an opportunity to have their voice heard and their rights protected. Thank you for joining us, Meghna.
Thank you.
Uh, this is going to be a free-flowing conversation where we will begin by discussing your experiences with the courts and see how we can ensure, and also your experiences of how the courts can be improved to ensure that the system is truly accessible, welcoming, and safe for all persons.
So, to start us off, could you let us know how long you've been practicing and what are the changes in how the courts work that you've observed over time, whether it's through, technological advancements that have happened, perhaps as a result of the COVID-19 pandemic, or any other changes that you've observed over your years of experience?
So I've been practicing since 2022 now. So I was not practicing during COVID-19. I was doing my clerkship at that time. So I could probably say a bit about what I saw at that time during my clerkship as well. Because again, that COVID-19 was a lot of changes for a lot of people. And even for people with a lot of resources who come from privileged background, it was a difficult time to adjust to. So even the judges it's just one judge that I worked with at the Supreme Court. They obviously had a team who would assist them in any technical difficulties. There would be a team that would assist in aid and ensure the process is smooth for them. But we can't say the same for the others, say the litigants or the advocates who are representing them. Of course, there were a lot of glitches, and I think we've come across so many reels, or I don't know, a lot of memes that have come on after these glitches during COVID. So, I think the court system in itself, at least from the years of experience that I've had, um, itself is so intimidating. So adding technology is an additional barrier to those who probably don't come from a very privileged background, who don't have access to these amenities. A lot of clients that I have seen at Dhwani don't have smartphones. Uh, of course, now there are people most people do have smartphones, but there is still a considerable section of society that does not have access to these. So things like even though technology, the aim is to make it more accessible, say for instance, e-courts, so that the litigants can track their cases or know what's happening in each on each date. It's meant to address that and to make it more accessible to everyone. But I don't know if a lot of clients that I have met at Dhwani are aware of something like this exists, that they still rely on the advocates. That's the primary source of any form of information. So there's a lot of trust that they put. It's a big responsibilities that the advocates have. So yeah, did I answer your question? Is yes.
Yeah, so just to expand on that a little bit, perhaps, because like you said that there was a lot of changes that were being introduced. So some of them being, of course, e-filing. There was also video conferencing extensively being leaned on when, especially during the pandemic. I understand that you're saying like for litigants, it did not perhaps like bridge, or like for some parts of the society, it did not bridge a lot of gaps. But do you think that perhaps like for say lawyers who are practicing, or for like judges who are practicing, was there like a easier process? Like, so what could have been done to perhaps make it a little more easy and fill in some of the gaps in some of these systems?
Right. So video conference, I think that definitely was a great, I mean, it bridged a lot of gaps, at least for advocates. I think it saves a lot of time also. Sometimes, you can't make it in time, then you miss your matter. But if you have the feasibility of appearing online and representing your case, then I think that's a great initiative to go with. But e-filing, I personally, since the time I have practiced, we have not done the e-filing either at the High Court. The only two times that we've used e-filing is once when we had a DRT matter, and with the when we had to file a consumer complaint, because here it's mandatory that you have to file it online. I mean, as well as you give them a hard copy of the file. It's also cumbersome, I feel like. I remember office being extremely stressed in the entire e-filing process is not very conducive, or it's not very easy. It's more complicated, and but I guess it also takes time. There are a lot of colleagues who think it's easier to do it online, rather than the physical copy. That is, if you don't have clerks, you just started off independently, so that really helps. uh, for the longest time, Dhwani also didn't have a clerk. So, but I remember as lawyers, we just did not go draft and argue the matter, but we were also involved in this process because we didn't have clerks, so we did the actual filing for the longest time. I E-filing would sort of double that work because you're doing it online, and as well as you're going and doing the physical filing as well. I mean, this is again coming from only the limited experience of filing it at the consumer forum as well as the DRT. High Court, I mean, even to this date in at Dhwani, we are filing physically. Like I said, we now have a clerk, so it's easier. I mean, for us, one less work for us. We're able to take on a lot more cases because of that. And conference, I think even in the High Court, even to this state, we're a lot apprehensive to appear online, because it seems like the some of the judges, not all of them, would hear you better if you're there physically, rather than you're making any submissions online. And even for not just appearing in any of the cases, but at times when you have to move memos or make any mention, you do it online, a lot of judges don't like it, they get angry in the High Court. So we still, even with these technologies in place, we still have to, we're still doing things physically. Yeah.
I think that's a very important point for us to remember, that even though we keep talking about these digital technologies and advancements, the physical process is not going to go anywhere, right?
Yeah.
It's still here to stay. And that requires us to think a little deeper about how we can ensure that the physical space also is, improved, rather than just relying on digital solutions to everything. So, but in this regard, just to sort of pick up on another point that you mentioned earlier about how persons who are coming to court for the first time, especially, or from vulnerable persons, etc., already view the system as intimidating. So, and as you've said that in your experience, you've noticed that clients who do come to the court for the first time feel that the court isn't really a very welcoming or comfortable space. So, what are some of the steps that you as an advocate would take then to ensure that they feel more comfortable? And what are the what do you see that people need to do to ensure that we sort of help bridge this gap a little?
Yes, I mean, the physical infrastructure of these courts itself, at least the, I mean, from the top of my head that I can think of. I mean, even to this date, the toughest court that I find to locate the court halls is the city civil court. I always get lost there. And I mean, at Dhwani, our practice is that we inform the client much in advance. We ask them to come a little early, and we are there at that time. We try to make it. If there's no clashes, we try to be there at the time that they are there. And we inform them of the court halls where their case is being heard. But the practice that I have done throughout my time here at Dhwani, and also I've seen my colleagues do, is that we meet them at the entrance of the court, and then we take them to the respective court halls. I mean, that seems like, at least the first hearing, it'll be less intimidating for them. I remember one of the DV matters that Dhwani handled. It was for a woman she's a Punjabi. She's from Patna. She had come here to Bangalore after her marriage, and things didn't go as planned, and she was filing a domestic violence case against her husband. And this was the first time this lady was even, coming before a court. I mean, it's another thing it's already intimidating to approach a court, but then you're in a whole different city where you don't understand the language. So I remember, like, she came with another NGO there, who assisted her in filing this. Who introduced her to us. She came with a few members from there. They need that kind of support sometimes, and hand holding to make it less intimidating. And even when she had all the support, and then she had her advocates who would speak on her behalf, she was just so anxious, and she kept asking, what's going to happen next? What do I have to do? What's my role? So it just helps to break down. Like, we tell them beforehand, most of our clients, we tell them what is it that's going to happen on that particular day, whether there'll be a hearing or it's just a matter of appearance, that they just appear and then it's a matter of 5 minutes. So we try to break it down for them to make it less intimidating. But yeah, I think it's nevertheless intimidating. Some of them would like to talk to the judges. Like in family court, it's still welcome that they are allowed. But a lot of times when they're very anxious and they want to make a submission, they think that their counsel missed out something, and they want to cover it, thinking that if they don't speak up now, they lose that chance, and they get reprimanded by the judges, and it's again demoralizing. It makes it more scary for them. Yeah.
Right. So you've spoken about, like, so say the NGO with which the client is already, involved, or you who are advocating for them, but there are other players who are also involved in the system, right? And that starts right from e- even before we start at the court, right? It starts from the police personnel. Once you enter, there's also prosecutors involved. There are a lot of court staff involved. There's a lot of, say, attendance in the court. There are many other stakeholders involved. So while you, as the advocates of the client, can do so much to make them comfortable, what do you think are some of the steps that maybe some of these other stakeholders take to ensure that when they already know that the person is a vulnerable witness, or like they are like a person who's visiting the court, is a new visitor to the court, or whatever it may be, to make them feel a little more maybe safe and comfortable in experiencing the justice system as such?
Right. So I've seen just two extremes. That I've seen the court staff being courteous and patient with clients, in a few matters that I've observed, where the advocates are not there, or they're running late and they haven't come, and the case is called out and the client just comes forward. A lot of times, these are the court uses jargons, right, which a layperson would not understand. So they're so confused, they wouldn't know what's happening. They just mention that my advocate is on their way, and even something as simple as a Passover, they would not understand what that Passover would mean. So I've seen the bench clerk explaining to them that it'll be called out again. But they've also seen others snapping at them and just saying, you you can go now, the next case is called, or just being rude. So I think I'm not sure where the court staff comes from. Is if it's just that one day that they were having a bad day that they reacted that way, or they just overworked in general. I mean, our courts are overburdened and overworked, right? And there are 100 things that even the bench clerk and other staff members are doing. So I think we'll have to see if they're understaffed, if they're overworked. These are some things that we need to consider, and maybe sensitize the court staff also to be more courteous and polite, uh, or at least just a little patient. It's a matter of few seconds. You don't have to be very elaborate in explaining the process, just to give them an idea of what they need to expect next, because otherwise it's just like a mystery. They barely understand what's going on. Yeah.
I think another factor that we have also observed sometimes in terms of causing discomfort in how the court proceedings work is the physical arrangement, the layout of the courtroom itself, where so there aren't enough waiting rooms to begin with, and then inside the court there's a full crowd, and so the litigant perhaps may not really know what is going on or how the proceedings really work, and they don't have clear audio acoustics to perhaps hear what the judge is saying up front at the dais and so on and so forth. So have you also perhaps noticed any instances where like these sort of physical infrastructure concerns have also been brought up as hurdles for litigants and others in general?
Yes, definitely. I think one instance would be the family court. I mean, I've always seen where at the beginning of the session, the bench clerk makes it very clear that, I mean, it's also very crowded. Apart from that, they make it very clear that only lawyers can, be inside, and the litigants have to wait outside. Uh, Even then, it's still crowded, but then a lot of times they call out the names, but it's not loud enough when they're waiting outside. So by the time they come forward, I mean, the case, I mean, it's passed over or it's adjourned. And also this specific space that they need, where they have to stand when the case is called. If your advocate does not explain to you where you have to stand at that given point of time, say if in family court, if it's a regular appearance, you have to go in between right before the judge. But if you're giving your testimony, then you have to come stand next to your advocate and then step into the box when when it's time, or when the court tells them that they can step in and read out the oath. So these are things. I mean, as it is, it's already crowded, right? Like I mentioned, that for them to make their way and then figure out where do I have to stand, that becomes very difficult. And sometimes they'll have to sign the order sheet, and then some of them just walk away without understanding, and then the court clerks just shouts and then ask them to come back. These are some of the hiccups that I see from the physical structure of the courts itself. Yeah.
Right. Another, I mean, since we are talking about like spaces where vulnerable witnesses may visit in a court complex, another such category of, unfortunately users is children in the court. So have you had any experiences in particular with children in maybe a family court matter or a POCSO matter or any such matter? And like in that experience, like how has the children felt? I'm not making it general, but I'm saying that, what are like some of these experiences that may have stood out, perhaps?
Um, See, with POCSO matters, I think procedurally there are certain safeguards with respect to the child not coming in direct contact with the accused, or the manner in which the testimony is taken. But in terms of family court, in a lot of instances, there have been in camera proceedings. But even that, where I've seen a lot of children in family court either waiting at the mediation center for their parents' mediation to come up, or even the case to come up. It's a lot of waiting. Like, I think as advocates, we ourselves feel so drained by the entire process of just waiting for the case to be called out and for you to just do your bit and come. But for the clients to wait along with their children all day, I've had instances where parents have come with their daughters in divorce proceedings, and they've had to wait for hours without food or water. And even like toilets are at such extreme ends, right? That that's another difficult process for them to navigate, and each time they'll have to ask, it's on different ends. And yeah, I think it for children, I think, I mean, for as adults, we are so drained and from the entire process. I'm sure they'd be I mean, they, because they first, they don't understand even the little bit that the adults understand. And for them to just not do anything, to be quiet or be, I mean, they're disciplined, and that they have to sit in a certain way, they can't speak to their parents. All of that adds a lot of I think yeah stress on the children.
So on this, just to expand a little bit on this point as well, have you noticed any specific child-friendly facilities at the family courts or the city civil court or elsewhere, such as child-friendly waiting areas which have any material to help entertain or distract children of all ages, not just very very small infants, or playgrounds or creche facilities or anything of those sort? Have you seen anything like that in person? Do you think it's up to standards to ensure that the environment is kept more safe and non-intimidating for them?
Hmm. In the family court, yes, there's a separate floor itself that's for children, for the parents to have their visitation rights and to play with children. But then again, I've not paid. I mean, it was just once that I visited this section of the court. But from what I remember, there were just a few toys for selected age groups. I don't think children who are much older, there's nothing that I can recall and think of, that either they had books or anything for them to be engaged with. But they were toys, like you have your balls and cars and what you would regularly expect in probably a creche. Maybe yeah, those a few toys. And then, I mean, it was probably painted a little more colorful to make it more pleasing, or pleasing for the children. But yeah, this is just, again, this is separate section, right? It's not within the, I mean, it's in the main building, but it's on a separate floor altogether. So that would mean, like, if it's a single parent coming, so without any assistance, without anybody, then they had no other option to, like, sit with, I mean, make the child stay with them until the case is called out and the matter is heard. They can't, they probably wouldn't feel safe to leave the child alone if it's too young on its own. And I don't recall too many staff members also there, probably a handful. So yeah.
So just, I mean, to continue on this, if, I mean, for you, because you work with the space and you work with various categories of vulnerable witnesses, if there could be one thing that you could change immediately, it could be something procedural, it could be something infrastructural, it could be something systemic, however, you want to go about it. And without legislative reforms, like we know, like for anything to change in the system, it takes a long time and a long procedure. So without that, to make like somebody's experience just easier in court, if there's some one thing that you think you can change immediately, what do you think? Aspirationally, what would that be?
I think I know this is a very low expectation, or very bare minimum. I mean, there are a lot in the civil code. Again, I'm going back to civil code because this is where infrastructurally I see a lot of changes that are needed. Right, there are a lot of lifts. Like, I mean, there are, I think, at least 4 different sections of the code where there are lifts, but not all of them are accessible, or all of them are functional. It's only 2 particular lifts that are functional and from a particular flow. So when I have to, imagine someone who has some form of disability, and the accessibility of it itself is so difficult. And again, the boards and signages also throughout the court, it's just in a few sections. Like when you enter at a particular location, there's or 2 3 locations, I think they mention where these court halls are, what court halls are on the floor. But then again, they mention main building, annex building, and so henceforth. But nobody knows. For someone who's stepping in for the first time, they don't know what's the main building, what's the annex building. It should be more, and again, it's mostly in English. So someone who can't read English, again, would not be able to understand. They still have to rely on somebody to ask for directions. And if that person, if most people are busy, they're just running in courts all the time, so if you don't get the help in time, then you probably will miss your case. So I think what we have right now, if we just if that itself is made to function better, we can work from there, is what I think.
I don't think this is a low aspiration at all. I think this is absolutely crucial. It starts from there. I think you're completely right. If someone enters the court and is confused by signs, not knowing where to go, and so on and so forth, then the whole journey sort of stops right there. So it's absolutely crucial that we definitely uh, work on improving these aspects. So, thank you so much, Meghna, for so generously taking out your time and sharing your insights with us. I think this was very helpful, especially to help highlight all of these issues that most people experience, but we don't really get to talk about it in as many ways. So it was really good to hear from you today. So we really appreciate all the thought and your expertise that you've brought to this conversation. And we hope that we can keep these conversations going and continue working towards a better justice system that's more inclusive and more truly accessible for everyone.
Yeah. Thank you so much for having me.